To talk a moment about medical bills because they are difficult for you as payers and payees of support. They are difficult for us as a friend of the court. And the reason that they're difficult is we're dealing with so many different types of medical insurances. It make it very hard for us to determine what was paid, when it was paid, how much should be paid. So we've developed a process in the Friend of the Court office to help you get through this. Okay, first of all, let me say this. With regard to medical bills, all the medical bills, if you want to have reimbursement on them, the request for reimbursement must be submitted within 1 year of the date that the service took place. Don't hang on to those bills, even though we won't process them after 1 year. But get them in as soon as the time after insurance coverage has lapsed. Get them into our office. So what we ask is when a medical bill is incurred, you will all have language in your order that again deals with percentages. And we touched on this a little bit earlier. Your percentages, what percentage you are responsible as payers of support and receivers of support for that bill. You will also have language in your orders that state that you must procure insurance, if available, at a reasonable cost through your employer. Okay, so if you have the availability to have insurance at a reasonable cost, you must or should have insurance on those children. So now we have a medical bill and somebody wants payment for it. We ask as a friend of court that you submit it to the other party with the proper communication. This bill was incurred on such and such a date for this, and according to our order, you're responsible for such and such a part. Okay? Now you need to try to submit them to your insurance companies if you have insurance. Before the friend of court even gets involved, we want to make sure that you've submitted it to the other party and you've submitted it to the insurance agent, insurance company. Once those two things have happened and the insurance has paid the money and there's still an outstanding balance and it's not being paid, then you can submit those bills to the friend of the court, and we will give you what is called a demand for medical form. That demand for medical form will say that this amount of bills were submitted and we're asking payment. That demand for medical form, as well as the copies of the bills, will be sent to the other party in the case who you're asking for reimbursement. They'll be sent to the other party. Now they'll be sent with a notice that says you have 14 days to object to this, or we're just going to add this right onto your account. Now if the person that is supposed to pay this bill doesn't object within 14 days, we simply add it right to the account. If we need to, we adjust the income withholding order so that an extra amount of money, $10 or $15 or whatever it can, comes through to pay off that bill. If there is an objection within 14 days, the friend of the court, again, will try to work it out outside of a referee hearing. The workers in our office will try to contact the parties and say, geez, this bill is still outstanding, and we will try to work with you. If all else fails, we'll set it on for a referee hearing. No, let me correct that. If all else fails, we will simply add it to your account. If you object to it, if you object to the 14 days, in the 14-day period, then you're entitled to the referee hearing. Is everybody clear on that? Because I think if you, let me say it once more because I think I didn't say it right. If within 14 days you object to it, we'll set it on for a referee hearing. If you don't object, we'll simply add it to your account and increase your income withholding order. Let me talk a little bit about other ways, for about 5 more minutes here, about other ways that we can collect child support. We have a program called the Tax Intercept Program, and in that program, any amounts due the state of $150, or any amounts due the state or to the payee of support of $150 or more, the state can come in and we can intercept your state taxes. $500 or more due and owing on your account, that we can intercept your federal taxes. It's an automatic occurrence that happens in our office. It happens every about August that we're intercepted for the following year. Whether or not you're on state aid, again, it's automatic. Some of you may have received notices. The state sends out notices that you've been intercepted in about October or November of each year. And after that, you have a right to request to be taken off of the intercept list by writing our office or telephoning our office. And we will review your case to determine whether or not you should be taken off. We also have a program of parent locators, which is a national program. If your name is submitted to the parent locator system, that system will turn over names and addresses and employers to the friend of the court. If you cannot find your particular payer of support, we would be happy to submit his or her name to this program to try to find where they're living, where they're working, etc. And finally, what I wanted to touch upon is liens in our office. We do some liens on, especially on workman's compensation, and so if you know that the payer of support in your case is receiving a lump sum of money, we would be happy to attempt to facilitate and put a lien on that particular lump sum that he or she may be receiving. Are there any questions? Yes, sir.
When do alimony and child support payments start? Do they start when one person moves out of the home, or?
Well, I really didn't even talk about that. The question was, when do alimony and child support payments start? Normally what happens is, in a divorce situation, and soon in January, the referees are going to start in paternities and separated situations, what they have is called a temporary hearing. And your paperwork must be submitted to the friend of the court, and the referees will determine on a temporary basis where custody is of the children or child is going to be placed, your parenting time issues, the support issues, and when support will begin. And in each case, sir, it's different. If you as a payer of support are living still in the house, then the referees may say, well, let's keep everything the status quo. You pay the bills you paid, mother paid the bills she paid, you know, you work together until a certain time when that is no longer feasible, and then, you know, this may happen, or whatever the case may be. So in each case, it's different, but if it's a general case when the parties are living out of the house, when it says in the order your support should start, on that day your support starts. Be mailed to the friend of court office. So your order is the controlling document of everything you do in our office. Yes, ma'am.
If you choose to not go through the front of the court for your support payments, is there, that $39 a year fee or any of the other fees, is that still due to the friend of the court, even if the friend of the court isn't handling those payments?
Okay, the question was, if you choose not to go through the friend of the court office, is the $39 fee still payable? And the answer is no. Okay, but you may work out between, if you choose not to go before the friend of the court office, say you don't have an order, whatever you do is fine. The problem becomes when it no longer works, and then you come back to the friend of the court office, and as statutory requirement, the friend of the court will prepare one audit per year for you. But if we don't have your records as to payment in our computers, that audit becomes impossible. And we've had people bring in literally boxes of canceled checks and said, I've made all of these payments for the last 5 years, and it is very difficult for us.
Right, is there something that the payee can fill out, like on a yearly basis or whatever, to send to you that says, yes, this has been paid in full this year, there has been no problems, or something like that?
Yeah,
That way there isn't, I've known of 3 men recently that received these things that said, you owe $25,000 or you owe $250,000, and they've paid on a regular basis directly to the mother. And they received this, like, what does this mean? And one man flew all the way across the country because he didn't know
Sure.
why he was getting this thing from a friend of the court when he'd been paying on a regular basis and having his visitation and everything was fine.
In many cases, the question was, you know, if you're paying outside of the friend of the court, is there a form that you can fill out that lets the friend of court know that you are doing this? And the answer is yes. It's called a direct payment slip. And if you are not going through the friend of court, it is very important that on a regular basis that we receive those direct payment slips so that we can credit your account. Otherwise, support continues to build and build and build. And what happens is at intercept season, which is right now, at intercept season, we will intercept your income taxes, state and federal, because we don't know that you've made this arrangement between each other. And then you'll get a notice that says you owe $30,000, and as a result, you know, it causes much anxiety. So if those forms must be turned into our office, they should be turned into our office on a regular basis. They should be notarized. They have to be notarized by the person giving the credit. Okay, and sent to our office. If you, ma'am, pay support, okay. If you
receive direct support.
If you agree to receive support, okay, you need to send that payment slip to us in a notarized form.
How do I get one of those?
All you need to do is contact our office and ask your caseworker. We'll send it to you. Yes.
Unless the order says pay directly, then it's not
See,
charged.
my order does say that. That's why I'm saying that.
Okay.
My order has it, and my court order says both, actually, and that's why my spouse did not understand when he read through this. It said that it was in the first part of the paragraph, it said it was paid directly to me on a twice-a-month basis or whatever on these dates. And then at the bottom of the paragraph, it said it had to be paid through friend of the court on a weekly amount.
Sure.
And I think what it meant was that if it wasn't paid directly to me and we did choose to go through friend of the court, it broke it down into a weekly amount.
Yeah. If your order says, you know, that he will pay you in your particular case directly, then you do not need to fill in those particular forms, okay? Your order, again, is the controlling document of everything that you have and every dealing that you have with our office.
So you'll look at that and say, okay, we don't have to worry about them
That's right.
unless she calls us and says she's not getting her money.
Unless you write us. Everything in writing. Okay. Other questions? I thank you very much for coming tonight, and I thank you for your attentiveness. We have given you friend of court evaluation forms, and we would appreciate it if those forms would be filled out and just left at the table here. It helps us improve this program. Again, thank you very much. Myself and my staff will be available to answer any other questions that you may have after the program.